To begin, starting with the affirmatives, they talked about how the death penalty is unfair to the mentally ill. However, it was established in the landmark case Atkins v. Virginia that plaintiff Atkins, he was in a case where he claimed that he was, the defendant claimed that he was mentally retarded. However, the American Psychological Association, after years of debate, they finally deemed a rate of IQ, which was at 75, which finally is that line that determines if they are in fact mentally ill, and if they are, then they are not allowed to be executed and it is unconstitutional now. However, so that they are determined based off the American Psychological Association, which is a credible source of determining their mental status. And then moving on to my partner's point about and if they have life without parole, it's not stopping them from murdering any more people. They are still in the prison system with the general population. So according to David Dow, who is a death row lawyer, he fights to keep his clients alive, and he believes that life without parole denies the possibility of redemption every bit as strapping a murderer to the gurney and filling him with poison. He has quoted that he's had clients in the past who want them to fight for his life, and then when they win and their death sentence gets converted into life, they end up telling him that they betrayed him. Additionally, according to John Cloud in his article regarding Death's Door in Time magazine, he said that he was in a case with Kenneth McDuff, who was a clear and present danger, and they wanted to put this guy in prison for life. However, he got out of that punishment and he murdered again. Additionally, they also can kill again in prison. It happens all the time, and he states that the death penalty is a necessity in these cases. Moving on to the Deterrent Act, additionally also with Justice Potter Stewart, he, according to Adam Liptek in his article, Does Death Penalty Save Lives?, there was a 4-year moratorium period in 1976 where they were reviewing the death penalty, and after that 4-year hiatus was up, he wrote for 3 justices in the majority of that decision, and he concluded the death penalty undoubtedly is a significant deterrent. Additionally, according to David Mulhausen in his Capital Punishment Works article in the Daily Signal, he found in 2009 that researchers that adopted state laws allowing defendants in child murder cases to be eligible for the death penalty was associated with an almost 20% reduction in these crimes. Now moving on to add to my partner's point about the constitutionality, several argue that the Fifth Amendment can be read as evidence that it says that they cannot be deprived of life. However, it also goes on to state that they cannot be deprived of life without due process of law, and that is why we have these trial processes with competent lawyers and an independent judge. And also in the Eighth Amendment, people argue that it is cruel and unusual. However, in the U.S. Supreme Court, Bays versus Rees, they said simply because an execution method may result in pain either by accident or an inescapable consequence of death, it is not established this objectively intolerable risk of harm that is identified as cruel and unusual. And Kentucky has also adopted a method of execution that is believed to be the most humane possible, and it shares it with the other states as well. Moving on to add to my partner also about the morality of the death penalty. According to David Mulhausen in his Capital Punishment Works article in the Daily Signal, a Gallup poll was conducted and it found that 61% of Americans viewed the death penalty as morally acceptable, and only 30% disagreed. And according to Edward Fesser and Joseph Bassett in their article, Why the Death Penalty is Still Necessary, they said that to sentence killers like those described above to less than death would fail to do justice to the penalty, presumably a long period in prison. It would be grossly disproportionate to the heinousness of the crime.